Be ready. Start. Revision petitioner in this CRP is the second defendant in O section 811 of 1993 and petitioner in IA 3082 of 1993. She filed a petition under section 10 of the CPC for staying all further proceedings in the said suit till the disposal of OS 106 of 1993 instituted by her. By the impugned order, the learned Munsif did not allow the prayer for stay, but allowed consolidation of the two suits. The said order is under challenge in this revision. Para. It is an admitted case that the subject matter in both the suits is the same. Defendants in OS 106 of 1993 are the plaintiffs in OS 811 of 1993. In that the plaintiff in OS 106 of 1993 and her husband are the defendants. Thus the parties in both the suits are substantially the same, particularly when, according to the petitioner, the second defendant has no independent claim and that he is looking after the property as her husband. Both the suits are for a decree of permanent injunction. The earlier instituted suit is OS 106 of 1993. As noticed, the petitioner filed by the second defendant in OS 811 of 1993 was to stay further proceedings in the said suit till the disposal of the earlier instituted suit OS 106 of 1993. Para. Learned counsel for the revision petitioner contended that it is a case where all the ingredients of section 10 of the CPC are satisfied and therefore the petition ought to have been allowed. On the other hand, learned counsel for the respondents contended that the petition itself is not maintainable. The condition under section 10 CPC is not satisfied, and he alternatively contended that the prayer in the petition is such that the same cannot be entertained under section 10 CPC. The prayer is to stay all further proceedings in the said suit, whereas under section 10 CPC only the trial of the suit can be stayed. Para. Before going into the merit of the argument, it will be convenient to understand the scope of Section 10 CPC. Under Section 10 CPC, only the trial of the suit can be stayed and the conditions therein. The issue in the earlier suit should be directly and substantially in issue in the subsequently instituted suit. The said suit must be between the same parties or their representatives, and there should be identity of title agitated in both the suits. Para. Here there is no dispute that the subject matter in both the suits are the same, except that in OS 811 of 1993 the husband of the petitioner also is made a party. The parties in both the suits are also the same. For the purpose of the operation of section 10 CPC, it is not necessary that all the parties on the either side should be the same in both the suits. It is enough if there is a substantial identity of the parties. From the averments in the affidavit, it is clear that there is a substantial identity of the parties in both suits. Stop.